So today we are, well, for those of you that may not have met me, I'm Lori Dunagan. I'm one of the coaches with the PC program. And while Brittany normally does the workshop on Mondays, usually on the first Monday of the month, I take over and then I do a workshop on contracts. So today we're going to be talking about three different contracts. I think last time we talked about the listing agreement, the time before we talked about the purchase agreement. And so today we're going to be talking about the seller in possession form. We're going to talk about the seller purchase of replacement property form. And then we're also, assuming we have time, we're going to talk about the tenant occupied property addendum. So those are three forms that that you may come across as you start representing both buyers and sellers. Because if you're representing a buyer and they're going under contract with a seller that needs one of these items or has a tenant, then you'll come across them that way as well. I'm going to share my screen and we'll go over the different forms. And I will stop and ask you guys if you have questions. But if you have questions, unmute yourself and let me know what questions you have. I'm going to, when I share my screen, I lose access to part of you guys on Zoom. And so if you use the emojis and you just raise your hand silently, I may not see that. Or if you put your question in the chat, I also may not see that. So just interrupt me. Let's make this conversational. And let's learn some things today. So let me give me just a second to pull up my what I want to share here, and then I will get started. All right. Have any of you guys used this form before? Nobody? Okay. So sometimes when a seller is selling their house, they want to keep possession of the home for a period of time after escrow closes. In a typical transaction, once the transaction records, it's closed, that is the moment that the buyer now has possession and the seller should be moved out prior to that. But if the seller needs a few more days to maybe to get moved out, or because maybe they need the money from closing the transaction to pay for their moving costs, or maybe they need that maybe they're purchasing a second home and they would need those to close concurrently, and they don't want to get all their stuff like sitting in a moving truck for a couple of days until they do that. So there's a number of different reasons why a seller might want to stay in possession. It's a little bit risky to the buyer to have the seller stay in possession, just because, there's the unknown of, will the seller actually leave, or will they leave it in the condition that, you want it left in? But it's common. We definitely want to use a seller in possession form anytime the seller is going to stay, even if it's just for one day, because this form outlines some things that might not get discussed or recognized otherwise. The seller in possession form is commonly referred to as the SIP, and it is intended if the seller is going to be in possession for 29 days or less. And I recommend, if you can, have your seller be 29 days or less, because if it goes 30 days, then there's a residential lease, the RLAS form, that gets used. And this seller in possession form is a quick and easy 2-page document. And the lease document is multiple pages, and it gets into it's basically more like a rental agreement, and gets into a lot of things that it's easier to avoid if we can have them be there less than 29 days. So usually it's going to be either an addendum to the purchase agreement or the seller counter offer. If I'm writing if I'm writing a contract for my buyer, and I know, because it's in the MLS notes or I've talked to the agent, I know that the seller wants to stay in possession, I will usually submit this form with my offer. Because then that reduces that extra step of the seller having to do a counter offer. And if they get multiple offers, I want my offer to be like the easiest and cleanest. And if they don't have to do a counter offer, it just speeds things up. And it shows that we are, easy to work with and accommodating of the seller needs. So if it's an addendum to the purchase agreement, then we don't need to mark any boxes up here at the top. But if it's part of a seller counteroffer, then we would, check the box and put counteroffer number 1 or whatever the case might be. Or if it's part of a buyer counteroffer.
Lori, quick question.
Dated, this is, yes.
So the seller say that they put it in the MLS, the buying agent doesn't see that. Would they automatically go ahead and submit the form as a counter?
Yeah, they would then, if they have a good agent, they would submit a counter offer and put that in there.
Sure. Thank you.
So here where we say dated, this is going to be the date of the purchase agreement, not the date that the purchase agreement was signed, but at the very top of the purchase agreement, it says date filled out. So that's the date. So maybe we're 5 days after the offer has been received and we're doing a counter offer. We're not putting today's date. We're not putting the date of, whatever. We're putting the date that the RPA was originally filled out. And so that's because if we end up having maybe more than one purchase agreement, maybe they submitted an offer, then it got withdrew, then they did a second offer, whatever, we know which purchase agreement or counter offer or whatever that we're referencing. So that's the importance of dated. We're going to fill out, the address of the house and then who's buying and who's selling. And then we come down to the meat and potatoes of this agreement. So first of all, this nowhere in this form do they reference rent. So it's not a rental agreement. It's not anything like that. They're trying to avoid creating a landlord-tenant relationship, but it does say that right here, buyer is advised to consult with a qualified local landlord attorney to discuss whether the possession could be interpreted as creating a landlord-tenant relationship between buyer and seller. So they're trying to avoid that with this form, but they're also cautioning you that that relationship might be created if you let the seller remain in possession. And, tenants have a lot of rights. And so, the last thing you want is your buyer to be buying a house, intending to move into it, and all of a sudden having to deal with a tenant who essentially used to own the house, because we're not talking about an actual tenant, we're talking about the seller here. And for the most part, everything goes nice and smooth, and and we don't have to worry about that stuff, but just be aware that once in a while something can happen, right?
Lori,
okay. So yes.
Let me ask you. Okay,
yes.
So if you have a seller who has a tenant, has a roommate, what documentation do you need for that? And do you need it?
So in that case,
they're all moving out. They're all moving out at close. He's been. Do you need?
Yeah. So I would use the Tenant Occupied Property Addendum, which we will probably go over at the end if I have time. Yeah. Okay. And you don't have to use that form, but you should in that scenario. And I'll talk about that when we get there.
Yeah, because I had a crazy scenario. So, okay.
Yeah. And you never know, because crazy scenarios do happen, right?
Oh,
and so.
Yeah. I have to tell you.
Yeah. And our job is to protect our clients. Sorry, Lisa, go ahead.
My client was either going to be in his brand new mobile home that they were going to set, or he was going to be in Hawaii. Well, guess what? The mobile home didn't get set in time. The concrete wasn't even down, and Hawaii burnt down. Who would have come, right? So anything can happen. Timing,
right?
Only in my world would Hawaii burn down, but
our job as agents is to protect our clients to the best that we can. So, sometimes things happen, but our intention is to protect our clients. So this does say the addendum is intended to grant seller a license to remain in possession. So again, not a rental agreement, but a license to remain in possession. It's intended for short-term occupancy, which would be the 29 days or less. It's telling you to use the RLAS form if it's going to be longer than that. And it does say that local rent control and other law regarding tenant rights may impact buyer and seller's rights and obligations. And then it's a lot of people don't know how the days count. So this is not only for the license, the seller in possession form, but also for a contract. So close of escrow counts as day 0. So if they have 15 days to stay, the day that escrow closes is day 0. The next day is day 1. And so it puts it right on here. But just for like a purchase agreement, the day that they go, that it's signed and accepted by both buyer and seller, that's day 0. The next day is day 1. So when we're talking about a 30-day escrow, it counts similar to what this is saying. All right. So we get to put in that the seller is granted a license to remain in possession for a certain number of calendar days or a specific date. And sometimes escrow gets pushed back a little bit. So if we close 3 days later, we want to make sure that we didn't put a date to give them 3 days, because now our date no longer isn't accurate. It no longer gives them those 3 days. So depending on the situation, you would either put a number of days or a specific date. I like to give them until midnight, because if you give them till 6 p.m., then all of a sudden the new buyer is anxious at 6 o'clock to move in. And if the seller ends up moving, it takes an extra hour or two. Nobody really cares that much at midnight, but they might care at 6 p.m. So I like to just put midnight in there. It makes things a little bit easier. Although it does say the seller has no right to remain in possession beyond this term and may be responsible for court-awarded damages if seller does remain. So this is where it's a little bit risky to a buyer to allow a seller to remain in possession, because what if they don't move? Well, then you have to get, court involved in all of that. So, but in our market, seller in possession is a very common request from sellers. All right, so consideration. Are we, as the buyer, are we going to charge the seller to stay in the house for those 2 weeks or 2 days or whatever it might be? Or are we going to let them do it at no cost? A lot of sellers will request that it's done at no cost. A lot of buyers will agree to let them stay at no cost. Keep in mind that in the meantime, the new owner of the home, the buyer, has mortgage payments that are due, and probably at a higher amount than what the seller is. So the seller might be used to having a monthly payment of $2,000 a month, but because they sold it at a higher price, now the new owner's payment might be $4,000 a month. So even if we're like, well, we'll let you stay at your daily rate, is it the daily rate of the seller's mortgage or the daily rate of the buyer's mortgage, right? So anyways, you can put a certain dollar amount per day or a flat amount. And then that money will usually come out of the proceeds from the escrow, so the seller's proceeds. I would mark this box to have it be held in escrow. Let me see here. Seller shall deposit such funds with escrow holder prior to close of escrow, or funds shall be withheld from seller's proceeds. At close of escrow, all consideration would no. On this one, I would have it be released to the buyer, because it also says that if the seller vacates early, no portion of the consideration will be returned to seller unless otherwise agreed in writing. So if we're going to do $100 a day for 15 days, that's $1,500. If they move out after 7 days, that would only be $700. Are we giving them that extra $800 back? This says no, unless we have agreed in writing that we would. But at close of escrow, I'm going to go ahead and release that to the buyer because it is the buyer's funds. If it's put in escrow, then there shouldn't be any money that's paid outside of escrow, but there is a portion right here on 2B to put, if there's a late charge or if there's a non-sufficient fund fee. So you can fill that out if you want, but it probably won't apply. Seller's obligations for condition of the property. Okay, so this is saying that the seller, and remember, the seller may have lived in this house for 20 years and now they sold it. So technically they no longer own it, but they haven't moved out. They're still living it as they've, they kind of still feel like they own it because they've not moved out and they've owned it for 20 years, right? Maybe 2 years, whatever the number might be. But this is saying that the seller is going to maintain the property, the pool, the landscaping, all of that, in the condition that it was when it went under escrow and when it closed. Says seller may not make any alterations to the property without the buyer's consent, which of course seller no longer owns it, so we don't want them making changes. The delivery of possession fee delivery of possession. So again, in the same condition and terms provided in the purchase agreement. And then there's a delivery of possession fee. Now, I do like this fee. This is kind of like a security deposit. So the seller is going to leave, let's say, $2,000 in escrow, and this is the box I would mark where it says held in escrow. I would not release this to the buyer. So the seller is going to leave $2,000 in escrow, and then when they move out in 15 days, if they move out on time and if it's left in good condition, then buyer authorizes that $2,000 to be returned to the seller, no problem at all. But if they don't move out or they trash it, then the buyer has some funds that work kind of as a security deposit. So it incentivizes the seller to leave it in good condition. This could get ugly because if it's not left in good condition, is $2,000 enough to cover it? Does the seller agree that it was not left in good condition? Like, there's all sorts of things that could come up because of this, but I just like to have this as at least an initial point.
Can I ask you
Here it
something
says
about that
seller's
real
going to
fast?
pay. Yes.
Let's just pretend everything's in escrow, going smooth, and then the seller says, no, we need more time. They sign this agreement. Does the seller let's pretend they have equity in the house. Do they use the money from equity to go that $2,000 into escrow, or do they have to pay $2,000 out of their pocket to do this?
Could be either way. It could be either way. Usually it's taken out of their proceeds in escrow. And this would be seller in possession. So this isn't like we're in escrow and we need more time to close, so we're going to extend the escrow. That would be a different scenario. This is just if once we close escrow, we need some time to finish packing and get moved.
So they're going to know this before they even go into escrow, you're saying?
They would know it before. Now,
Okay.
if you're in escrow and all of a sudden the seller says, you know what, I need to stay in possession, that would become a negotiation point. And at that point, would the buyer agree to it? Would the buyer not agree to it? So it should definitely be negotiated as part of the original contract. Because once you're in escrow, the buyer has no incentive to agree to it. When the buyer is trying to get their offer accepted, they have an incentive to agree to it.
Right. And you said this is common. I'm just not understanding why they wouldn't just wait and put their house on the market, say 2 weeks later.
Well, this is okay. So this is after you close escrow, they're going to stay in the house for 2 weeks or 2 days or whatever. So normally, when you're selling your house, it closes and then you get the money like the next day, right? Maybe that day, maybe the next day as the seller. But what if I'm moving to another state and I have to pay the movers and I have to, there's all this expense with moving and the movers can't come until the day after we close escrow. Like, this is where a
things
seller
aren't
just
lining
needs that.
up and you don't
Yeah,
know till the close of escrow.
Well, and this is where the seller needs that extra time. I mean, maybe I have to pay the movers $10,000 to move me to whatever state, but I don't have that money until I get it from closing the house, but I'm not going to have it until the next day. So I can't be moved out before it closes because I need the money from after it closes.
Gotcha. Okay.
So there's different scenarios where a seller would use this form, but basically it's when the seller wants to stay after the close of escrow. Okay. Any other questions? Okay. So then this is saying that the seller during that, 2-week time has to make the property available to the buyer if they want to enter it to make any necessary repairs or have contractors come, or they want to show it to tenants or whatever the case might be. But they do have to give 24-hour notice, and also says that in the case of an emergency, the buyer can enter, the new owner buyer can enter at any time. This identifies, are we giving the keys to the new buyer, the new owner, when escrow closes, or are we giving it to them 2 weeks later when we actually move out? It says we cannot, sublet the property. So if I've got permission to stay for two more weeks, I can't then let someone else come in and stay for those 2 weeks instead of me. Insurance is something to consider. So the seller has homeowners insurance, right? Because they own the home. But once escrow closes, they no longer have homeowners insurance because they're no longer the homeowner. But if something happens, let's say a week after escrow closes, there's a fire. Well, now the seller's stuff isn't covered because the seller no longer has homeowner insurance because they don't own the home, right? And so then do they try to get renter's insurance? Can they even get renter's insurance for 2 weeks or not? So that's where they need to talk to their insurance person and kind of figure out how can I be covered if I'm staying in this house for just 2 more weeks, right? So just something to mention to them, and then they can decide whether they inquire about insurance or not. But as the seller who no longer owns the home, the new owner's insurance isn't going to cover me or any of my stuff. So just, something to know. And then the other thing about this, which really isn't addressed too much in here, but let's say you closed escrow and you're going to stay for 2 weeks, and a week later, the house floods or a pipe bursts or the air conditioner breaks, right? Think about the different mindsets between the buyer and the seller. The seller's like, oh, wow, well, I don't own the house anymore, so I don't have to pay for that. But the buyer's like, yeah, I own the house, but I haven't moved in yet. You're still there. You should be responsible for that. So you can see where conflict can come up that would have to be addressed. And so that's why this is like a little bit of a risky scenario. And at the same time, it happens all the time. So the chances of something like that happening are small, but just, be aware that something could happen. If there were any other terms or conditions, you can write that there. And then buyer and seller sign and agree, to whatever is put up here. And again, this should be done when you're submitting the offer and not after the fact. Any questions on it?
Lori, I did have a question. And it was something when you were, I believe you were answering Michelle's question. It seemed like we might have skipped over it regarding utilities, or maybe I just missed it. Who normally covers that in that situation? I know what the agreement says, but what's the reality?
So normally the seller would still have the utilities in their name, because there's a point where the seller is going to move out and then they'll turn off the utilities in their name. And so at this point, even though escrow closed, the utilities are still in that seller's name, and the seller's the one that's still using the utilities. And so most likely it would be in the seller's name. And then when the buyer takes possession, it would get transferred into their name. Now, like pool service, which it does say that, seller would still maintain like the pool and all of that. But if you have somebody coming and cleaning the pool or whatnot, or the yard, is seller still paying for that? They probably should be. They're still living there, but at that point, they no longer own it. So,
okay, thank you.
Any other questions? Okay, so it's really a pretty simple form. You just want to make sure that buyer and seller are understanding the pros and cons of staying in possession. The other thing to take into consideration, and I don't think it's usually a problem, but there are certain loans where the buyer has to take possession, right? They're buying it as their primary residence. They're not buying as a rental or an investment property. And so in that scenario, you might also check with the lender and make sure that the lender is okay with the seller in possession. Usually they are for, the 30 days or whatnot. But if it's going to be like 60 days or 90 days, and we're using that the residential lease agreement, that might be a different scenario, and they might not be allowed to even do it. So something to keep in mind as well. The seller in possession form is marked on the contract or in the counteroffers, and the lender gets a copy of that anyway, so the lender would know, what was happening, but it's not a bad idea to check with them. Okay, so then let's now talk about the SPRP. Okay. This one gets a little more complicated. I usually teach this with another form, and then it gets really confusing. So I'm only teaching this form today, and I'm not teaching the second form hopefully so it doesn't get so confusing. But this is the seller's purchase of replacement property. So in this scenario, the seller is selling their house, but they're also buying their next house. and they're making the sale of their current house contingent upon them being able to buy their second home or their next home. And so that's where they would use this contingency. So again, this is going to be addendum to either the purchase agreement or a counter offer. We've got our dates, we've got our names and our address up here. So we have a couple of choices here. This is going to either be contingent on them finding their replacement property, which means as a seller, I've put my house on the market. I know that I want to buy maybe a bigger house or a smaller house or a house in a different area, but I haven't found that house yet. And so what I'm saying is that once we go under contract, by default, I have 17 days to find that next house. And if I don't find that next house in the 17 days, then I'm going to remove this contingency or cancel the sale. So basically in this scenario, the buyer gets their offer accepted, but they're kind of in limbo for up to 17 days to see if the buyer is actually going to, not only find the replacement property, but get their offer accepted on it, right? And this number doesn't have to be 17 days, but it defaults to that. And then basically the buyer has to wait the 17 days, and then they can give the seller a 2-day notice to perform, and then they can cancel the agreement if they don't want to wait longer than the 17 days. Let's say that the seller hasn't found the replacement property, or they can give them extension, let them have 10 more days to find their property. Different scenarios can happen. Or B, and this is the stronger place to be, the seller has already entered into a contract. So they already have their house, they're under contract to buy it. And now we're just going to give the information so that, as the buyer's agent, if you want to verify that they're actually under contract and all of that. So scenario 1 is they don't have a house yet. Scenario 2 is they're already under contract. But then we have and C, and C is important regardless of whether we're doing A or B. And C says that not only do they have to find their replacement property and get under contract with it, they actually have to close on the property. And if they don't close on the property, then they can cancel the sale and don't have to sell their home. And so there's lots of reasons that a property can fall out of escrow. And so if you're representing the seller, you definitely want to make sure that you're marking this close of replacement property so that if their purchase falls out of escrow, they don't still have to sell their existing home. Does that make sense? Any questions on any of that?
So we need to mark either A, B,
Yep.
and C.
A or B and C. And even when I'm representing the buyer, so C is definitely in the benefit of the seller, right? It's not to the buyer's benefit here. But if I'm representing the buyer and I'm filling out this form because I'm going to do it because I know that the seller needs to find a replacement property, I'm still marking this box because I know that's what the sellers and the seller's agent's going to want marked. And again, I'm trying to avoid a counter offer scenario. So, I'm giving that to them. Okay, and then time periods. So as the buyer, if I just got my offer accepted and it's a 30-day escrow, but the seller has 17 days to find their replacement property, does my 30 days and my inspection period, does that start now or does that start when the seller goes under escrow on their replacement property, right? It makes more sense for it to happen when the seller finds their replacement property because I could go in as the buyer and do all of my inspections and 17 days go by and the seller never found a replacement property and now they can back out of selling me their home and I've invested money in inspections and appraisal and all of that. So I'm going to wait until they're under escrow. Now, if they're already under escrow because they've marked number B, then it would all start immediately, right? So that's where it's going to default to the day that the seller finds a replacement property and goes under contract. But we can check the box for it to remain as in the agreement, which I don't see why we would do that. Same with buyer's deposit. Normally the deposit's due within 3 days. Is it within 3 days of our offer being accepted or 3 days of the seller going under contract? So usually it'd be 3 days of them going under contract. Close of escrow. Here we are agreeing up front that the seller can extend the close of escrow date by a certain amount of days or until a specific date. I usually leave C blank, but if we want to agree up front to extensions, we can do that right here. And then if there are any other terms that we want to put in there, we can write those in D. I've never written any other terms. Okay, any questions on that? Okay, so then removal of contingencies, and then the buyer's right to cancel, seller's right to cancel. Okay, so up here, when they have to find the replacement property, it says that, let me see, that once their offer gets accepted, they will remove their finding replacement property contingency. So down here, it's just saying that even after that 17 days expires, seller retains the right to either remove that contingency or cancel the agreement unless the buyer cancels because of that as well. Once the buyer receives the seller's written removal of the finding replacement property contingency, the buyer can no longer cancel based off of that. I know that was a little bit confusing, but it's common sense though. And then buyer's right to cancel. So it's saying that buyer can cancel if the seller doesn't remove their finding replacement property contingency, or if they fail to remove their closing on replacement property contingency. So up here, where this says that they have to close, that the seller has the right to close on the replacement property. It says seller by the scheduled close of escrow date shall either close escrow or remove this contingency in writing. So this doesn't account for any extensions. So, you know, if the replacement property is supposed to close on March 15th, but there's something going on and now it's not going to close until March 18th, this isn't giving them the right to extend that by 3 more days. It's basically saying it was scheduled to close on the 15th, and so the contingency should be removed by that date. So I know that last part, I kind of made it a little bit confusing, but any questions? Okay, so you guys understand when you guys would use this form?
I feel like it's one of those forms that you won't understand it until you go through it.
Yeah.
After all that.
Yeah. And that's the thing, is you want to just make sure, like any form that you're filling out, because checking a box or not checking a box could completely change the meaning of the form or what agreed to in the form. So when you do fill this out, make sure you're reading it and understanding like all the different pieces of it. And if you don't understand something, ask somebody.
Right. And you would fill this out if you had a seller that their intention is to move out of state. They want to have escrow close on the same time on both homes. And then obviously that's when you start getting into timeframes and hoping everything lines up.
Yeah, even if they were moving right next door, you still want to use this form. If they need the money
Sure.
from this sale, well, not even if they need the money, but just if they, you know, because I can be under contract to sell my home and under contract to buy the next home, and for no fault of my own, either one of these could fall out of escrow, and they could fall out of escrow on the very last day, right? I'm buying a home, everything's going smoothly, and then all of a sudden the seller says, you know what? I changed my mind, I'm not going to sell the home. Now the seller doesn't have the right to do that, but there's nothing stopping them from doing that. And then all of a sudden I can't buy their home. Well, I'm under contract to sell this home and this one's closing. Now I'm homeless. I have nowhere, you know, I have to sell my home. I have nowhere to go because all of a sudden this seller's decided he's not going to sell it. And so this protects me from being homeless as the seller.
Or
It's
also,
basically,
yeah, didn't you say also if the seller agrees to an offer and then the buyer's putting out money on inspections and different reports and now they're invested in it? I mean, you have that issue too of them backing out.
well, and that's something that's something when we're talking to our clients that we have to explain to them as well. So when we're using a form like this, you know, it's a domino, like this has to happen, and then this has to happen, and then this has to happen. So we're going to do our inspections, right? We're, as a buyer, we're going to pay for the inspector, we're going to pay for the appraisal and all of that. And then if the seller then falls out of escrow on their replacement property, maybe they did their inspections and there's a big inspection item and they don't want to buy it, they can't come to, you know, agreement on repairs or anything like that, they're going to back out. And now they're going to cancel this agreement with you, the buyer, and you're out your money for your inspections. Like the seller doesn't have to reimburse you for that. So that's a risk to a buyer in doing a transaction like this, is that they're dependent on not only them and their seller, but now they're dependent on their seller's seller. So, you know, and we've seen scenarios, you know, because then like, what if you as the buyer are selling your home and now you're dependent on your buyer? So you're dependent on your buyer, but you're also dependent on your seller, but then you're also dependent on their seller. Like it can get, you know, it can get convoluted here. And there are risks, but that's the same thing when you're just buying a house too. You know, you have to spend money on the reports and on the inspection reports and on the appraisal. And maybe you don't come to you know, you don't come to agreement with the seller on repairs and you back out. Well, you get your EMD back, but you don't get your money you spent on inspections and appraisals. So that's always something that your buyers need to be aware of as well when anytime they put in an offer, but in particularly when they put in an offer where the seller's getting a replacement property.
Lori, has there,
Yeah.
excuse me, my voice, has there been instances where because of this risk that one will put in terms and conditions, or not terms and conditions, but whatever that terms thing is, that if the seller falls out of their escrow, that they will cover expenses to a certain amount of the buyer's inspections and whatnot, or does that get a lender kind of involved?
No, you could put that in there. I don't know what a lender would say about that. You could put that in there, but it then weakens your offer because now the seller has an extra cost, because you figure if the seller falls out of escrow, well, they've done their inspection costs and they've done their appraisal fee, and now they're not getting that reimbursed. So they've lost that, and now they have to reimburse the buyer for theirs when no one's reimbursing theirs. So, you know, is your offer going to get accepted in that scenario?
It's true.
So
good point.
yeah, so there's a lot that goes into these things, you know, a lot of different scenarios that can happen. And so we don't want to scare our clients, but we want to just make sure that they know up front, like the pros and cons and what could happen. And then they get to decide whether they move forward or not. And then if it does fall out and they lose their money, it's like they're not mad at you because you told them up front that that was a possibility. So there's a risk that they lose their inspection costs, but then there's the risk that they don't get their offer accepted if they don't agree to, you know, whatever the terms are. So, you know, we just want to do pros and cons and make sure that our clients are aware.
Or because of that, we make it not smooth.
Yeah. I mean, we want it to go as smooth as, you know, as smooth as we can for our client. So, and that's why it's important, again, that we are reading these forms, we understand, we come to the contracts classes and, you know, hear about the different scenarios so that we're not caught off guard either, you know, if something happens. Okay, so I'm going to switch hats here. We're going to now talk about the Tenant Occupied Property Addendum. So this would be when there's a tenant in the house or in the property. And sometimes when there's a tenant, we want the tenant to stay. Sometimes there's a tenant and we don't want them to stay. Maybe there's multiple tenants and we want 3 of the tenants to stay, but we want 1 of the tenants to leave, you know, because we want to move in there or for whatever, you know, scenario. So this is there's a box on the purchase agreement that gets marked when it's a tenant occupied property, and then this addendum would get added. So this is for 1 to 4 unit properties. And let's see. So it's an addendum to the purchase agreement or counter offer. We've got all the same information in the top. So tenant shall mean any adult person other than seller who is occupying the property, whether or not paying rent. So this goes to your question earlier, Lisa. If you have a roommate and you own the property and the roommate doesn't, well, the roommate is a tenant, right? Technically, it could go to, I own this house and my adult son lives here. And so he's not a tenant because I don't charge him rent, but he's also not the seller of the home. And so technically, he would be a tenant as well. Although I think in most scenarios, we don't think about it that way. But technically, by the definition here, any adult person other than the seller who is occupying the property, whether or not paying rent. Okay, if we want the tenants to remain in possession, then that's what it defaults to. We don't have to mark number B, it just defaults to A.
Thank you, Lori. Thank you.
Yeah, but if we want it to be delivered vacant, then first of all, the entire property or units 1 through 3 or whatever shall be delivered vacant without the existing tenants. But what if the tenants don't move out? And when do we want them to move out? So first of all, tenants have rights. And so depending on how long they've been in the property or what their lease agreement is, they've got to be given either 30-day notice or 60-day notice, or maybe they've got their lease that's in effect until July, right? So depending on what scenario that is, determines on whether we can make the tenants move out or when we can make them move out, right? And then there's rules on reasons why you can and can't evict tenants, but that goes into a whole nother conversation. So this says, so first of all, here's this box, 5 days prior to close of escrow. So I would recommend that you mark this box if you want the tenants to move and have them be moved out 5 days prior to close of escrow. That way, when you do your final inspection with your buyer, you can go in, you can see that the tenants are moved out, you can see the condition that they left the property in, you can address, whatever needs to be addressed. Because otherwise, if they are going to be moved out by close of escrow, you're at the mercy of, we closed escrow at noon. Did they move out before noon? Right? So the 5 days just kind of makes it cleaner. And again, if we got to give them 60-day notice, then we've got to do a 65-day escrow. So something to keep in mind. But it also says that if seller, after exercise of good faith attempts and subject to the applicable law, is unable to remove the existing tenants, either by close of escrow or 5 days prior, then the buyer can either cancel the agreement, but in that case, their sole remedy shall be the return of the deposit and reasonable out-of-pocket expenses for inspection reports and appraisal fees. So this is one scenario where they would get their inspection fees back. Let me see. Or the buyer may elect to proceed with the transaction with the tenants in possession. So if the seller is unable to get the tenants out, buyer has a choice. Do we cancel or do we move forward? And that's going to be the buyer's decision. If you move forward, now you're the landlord and these are your tenants. And if the seller wasn't able to get them out, then good luck with you getting them out, right? So anyways, and then let's see, seller shall, prior to close of escrow, deliver to buyer the names of all adult occupants residing in the property other than the seller that are known to the seller, or the following are the names, or they can give them the names here. So basically this is saying that the seller has to give the names of everybody that's living in the property. And then if we use that seller in possession form that we just talked about, no tenant shall remain except. So if the seller's staying in possession, then, if the roommate's going to stay in possession as well, we would put the roommate's name here.
So regarding the tenants that remain on the property that are not vacated, are not being vacated, let's say, do the new owner or do the buyer has to do a new contract for them, or it remains the same as the last owner?
So it would depend, and that would be more of a question. Like I don't 100% know the answer to that question, and I don't want to pretend like I do. If they have an existing lease, that existing lease would, I think, carry forward. If they're on a month, you might be able to change it, but it's going to be subject to tenant rights and all of that. And so I would recommend talking to, a landlord company or something in that situation. Like we don't want to try to answer that question for our clients. Let them research what they need to do in that scenario. So this says seller shall transfer to buyer any unused tenant deposits. This is if the tenant is remaining in possession. So, when you move in and you have to give, $1,000 deposit or whatever. So as the buyer, you get that $1,000 deposit so that when the tenant does eventually move out, you've got that deposit to give back to them. If there's any prepaid rents or and the seller has to disclose whether the tenants are delinquent on their rent, so you know whether the tenants are current or not paying. Let's see. So government compliance. So this is saying that the buyer is advised to carefully read and consider the attached rent cap and just cause addendum, which may impact buyer and tenant's rights and obligations under the law. So we cannot uncheck this. So there's no way to give them this form without giving them this second form. It doesn't let us. And so what this rent cap and a just cause addendum is down here attached to it. And it says that, that there are certain scenarios where the rent is capped and you can only raise it so much. If you're going to terminate a tenant, you have, there's at fault reasons, there's no fault reasons, there's notices that have to be given. And so this has to go to the buyer so that they're notified of some of the rules that are going to go into effect if they take the home with the tenants in possession. So that's what that's doing, is that's giving them that. This just says that if the seller is proposing to make any changes to the existing lease, that they have to notify the buyer, and then the buyer also has to agree to that change. I would think that if you're in the process of selling the home with the tenants, that's not the time that you're going to make changes to the lease, but if there are any, it has to be agreed to by the buyer. If there's any personal property that's going to be included in the sale, then the seller has to give a list of what that personal property is. So the way I envision this, and maybe it covers different things, but let's say that I have it rented out, but I have it rented out furnished. So the furniture doesn't belong to the tenant, it belongs to me as the landlord. And so now I'm selling the home, and so the furniture is going to the new owner. So now the new owner is going to own the furniture because the tenant doesn't still own it. That would be personal property. And so then I've got to give the new owner a list of what personal property is conveying with the sale. Now, lenders don't want personal property to convey with the sale. But if you're buying an investment, so that's something, so the value of that property couldn't be included in the sale. So this is just covering that. And then let me see, seller documentation and additional disclosure. And so this is where the seller has to disclose, and then the buyer has time to review as part of their inspection contingency, the any rental agreements, leases, whatever agreement is between the buyer and seller. Buyer can ask for income and expense statements. So if I've got, a duplex and I'm selling it, the buyer is going to want to see, am I making a profit from this duplex, or are my expenses higher than what, my income is? So you have to ask for it, but you can ask for that. A tenant estoppel certificate. This is a form that a tenant will fill out where the tenant basically says, my lease is from my lease is existing through this. These are the terms of my lease. This is how much I pay. This is how much deposit I have. It comes with 2 parking spaces, like whatever. And so this is a way for the new owner to make sure that the tenants, what the tenant thinks the agreement is matches what the lease is, and just it eliminates any he said, she said type of thing. Now, tenants don't have to fill out this certificate. And if they don't fill it out, then the buyer doesn't really have an out because of that. I mean, I guess they could have an out because of their inspection contingency, like they're not happy with that. But basically, seller shall exercise good faith to obtain the tenant signature, but seller cannot guarantee tenant's cooperation. In the event seller cannot obtain it, then the seller has to notify the buyer and provide the unsigned form that was given to the tenant. And then if the tenant fills it out later, then the seller has to give that to the buyer. If the seller has any surveys, plans, engineering documents, permits, has done any type of structural modifications, they have to give that. And then basically the seller is representing that they have no knowledge that the tenant has any current pending lawsuits, litigation that's affecting the property or the right to use it, or is the subject of a bankruptcy. Seller represents that no tenant is entitled to any rebate, concessions, or other benefit other than what's in the rental agreement. And seller represents that the documents are used by the seller. Now here it says that the income and expense statements are and used by seller in the computation of federal and state tax returns. So something to just kind of note, I used to work for a CPA office, and, you know, sometimes expenses get not exaggerated, but sometimes, you know, you write off more things for tax purposes than what you. I'm just saying that when you look at a profit and loss statement for tax purposes versus a profit and loss statement, like there's 2 versions and it could be different. So it could show a loss for tax reasons and might not be a loss in reality. So I'll just put that out there. Any questions on this form? Any questions on anything we talked about today?
So regarding Los Angeles, that we have rent control, this is a big chapter to read and to go through. So it's like when the clients see that it has tenants to remain, they don't want to buy. It's like, no. It's hard to take them out. Sometimes you need to pay them to get them out, like give them 20,000, 25,000, like do whatever it takes to vacate them. And so it's a problem. Sometimes it gets, but that's how it goes. Yeah.
Yeah. And so, I mean, it depends on the buyer's motivation. I mean, maybe the buyer's buying it as an investment property and they want the tenants. Then, you know, maybe the tenants have been there, they're good tenants, they pay their rent on time, and then it's all good. I hope the tenants will stay. But if they're buying it for their own personal use and they want the tenant to leave, I mean, that's where they need to know. And most people have a general idea. I mean, tenants have a lot of rights. And if you take a property with tenants, you're taking it subject to those tenant rights. And that's what some of these forms, part of these forms are to, you know, explain that and kind of bring up some of the things that a buyer might not think about. But yeah, our state's not really landlord friendly in a lot of situations. And so then that's a decision that the buyer has to make. Do I proceed or do I not proceed because it has tenants? And then there are some areas that have additional rules above whatever's, you know, put in the form, or stricter rules than what the state rules are. And the stricter rules will usually prevail. And so that's where your buyer needs to understand that as well. But we have to be careful not to be that voice of, well, this is what it is. We always want to refer them to a city official or a code or whatever, because we never want them to come back and say, well, you said. So a lot of times it's like, well, can I use this property for an Airbnb? Sure, I don't see why you couldn't. Well, there might be regulations either in existence now or pending that are going to stop you from having an Airbnb. And so our response is, well, that's something you need to check that with the city official with, right? And a lot of times we're like, well, you know what? I want to be helpful to my client, so I'm just going to call the city and I'm going to ask the question. And then the guy on the phone says, no restrictions, you can do Airbnb, no problem. So then you take that back to your client, they buy the house, and now all of a sudden they find out, you know what? That guy I talked to at the city gave me incorrect information. Well, the buyer's still going to blame me for that, even though all I did is tell him what the guy at the city told me, right? So you always want them to have that conversation, because if they got the wrong information, they got it from the city, they didn't get it from you. And so we have to make sure that we are protecting ourselves in that manner. Anytime we're, giving information about something that a client has help with. So we can give them a phone number or tell them who to contact, but we don't want to make that contact for them.
Thank you. That's great. Yes.
Yeah.
Thank you.
Yeah. Okay, well, we're at 12:28, so if there's no more questions, I want to thank you guys for attending. I hope that going over those forms was helpful for you. One of you said that it's one thing to sit in class and watch someone go over it, but it's not until you actually fill it out that you're like, oh, okay, wait, I don't know what this means, or what about this scenario? So I always suggest that you guys go in and actually fill them out in a practice scenario. I don't know if you guys saw, but when I shared my screen, it was in zip forms, but it was a test transaction. And so anytime I want to just play with a form or whatever, I just go into my test transaction, I add the form, delete the form. I'm not going to mess up anything in there. So I would suggest that you guys have some sort of test transaction open in zip forms where you can just mess around and do the forms. And then, of course, once you get under contract, if you're part of the PC program, reach out to us and we can help you with those forms. But also make sure you're reading the form so you understand what your client's signing and filling out. But with that, I hope you guys have a great rest of your day, and I will see you guys in a month, and Brittany will see you guys next week.
Thank
Thanks,
you.
Lori.
Thank
All
you.
right.
Lori.
Bye-bye.